The Minister of Justice and Correctional Services is 100% liable to pay damages to Leeuwkop Correctional Centre inmates who had been tortured by prison guards. The Johannesburg High Court ruled on Thursday. But to understand what the judgment means, we're now joined by Nabeelah Mia, the Penal Reform Programme Head at Lawyers for Human Rights. Nabeelah, great to catch up with you this evening. Now, explain to us what are the broader implications of this landmark court ruling on the state's liability for torture in South Africa.
Well, Hugo, this is the first time a claim of torture has been found under the Torture Act. You must understand that torture is an international human rights law violation. So the minister has been found liable, and the South African government and DCS officials have been found liable for committing an gross international human rights violation. And this has shed light on things that happen every day behind the closed walls of prisons. And I speak for my clients who, while they're happy with this outcome, they see this as a win for the community at large and the prison community at large to finally shed light on the fact that those apartheid-style tactics that the judge mentions that we know about around torture that happened in prisons are still happening today, and hopefully this will bring an end to impunity around that.
Nabeelah, you talk about your client. Can you give us some insights into the type of torture that they suffered?
Sure. I mean, so our clients were beaten with tonfas, they were shocked with electric shields, they had gross violations committed to their body where they had searches done to various cavities. And then 4 of our clients were then subjected to what was effectively solitary confinement, which we know has been outlawed but is still practiced today.
Now, how typical are such cases that your clients experienced?
Hugo, we get complaints like that all the time of torture happening within prison settings, within detention settings. We act for persons who are detained, who are immigration detainees as well. And we know that the treatment that is happening behind the closed doors of detention settings amounts to torture. But the impetus, it's closed off. There's no information. What happens in a prison is closed off. Our clients wouldn't be able to show us pictures or anything of what had happened to them. But we get those complaints on a regular basis, and the amount of work that went into this case needs to go into every case like this. And there's not just enough information being shared on what's happening in prisons.
Nabeelah, are you there?
Yes, can you hear me?
Yeah, I can hear you now. Now, I want to focus a little bit on certainly that judgment that was issued by Judge Ellen Francis and what it means for the Minister of Justice and Correctional Services. Now, the judge said it is rather sad and disturbing that some of the events that took place during the dark days of apartheid continue to take place in our beloved country at correctional facilities, right? He also dismissed the government's version as a pack of lies. Now, he said it was shocking that some officials would gang together to come up with a version in an attempt to mislead the courts about what really happened at their facility. Now, just how much trust can we have in the Minister of Justice and Correctional Services and certainly the Justice Department?
I think that the correct way to have dealt with this as soon as the allegations came to light was to do thorough investigations and to punish those that were on the receiving end of those allegations. But because that is our obligations under international law. That as soon as someone raises a claim of torture, you as the state have an obligation to go and investigate that claim. But what happened in this instance was a closing of ranks by DCS officials, an attempt to mislead the court, to lie to the court, to not get their facts straight, and to not deal with the matter as it should be. As I mentioned before, torture is a gross human rights violation. And as correctional services officials, as law enforcement, we trust law enforcement or are supposed to trust them to uphold and protect society. But you cannot do so if this level of lying and misleading is happening.
Now, I'd like to make mention certainly of the court ruling and certainly what it means for the justice system in one regard, if you will, that these 5 individuals that you represent, or amongst those that you represent, were individuals that were in prison and guilty of various crimes, but that the fact that the law came to their rescue, came to their defense.
Yes, I mean, I don't know what to say in response to that, because I stand by the fact that how this should have been dealt with, and how this, we hope, will be dealt with, is that those that were implicated and mentioned by name in the judgment will be dealt with by the Minister and by the Department of Correctional Services.
Okay, now, I know you don't sound it too well, so I'm going to give you a couple more questions before we wrap up the conversation. Now, let's talk about what are the potential consequences or penalties that government may face as a result of being found, and I state, 100% liable for the torture of these inmates.
So in our papers, we listed the level of damages that our clients had suffered that relate to the level of physical injury, the ongoing injuries that our clients continue to suffer today, both physical and mental, because of the torture that they were subjected to. We had asked for certain monetary amounts, but because of forgive me, I'm going to go into some procedural law here. The way the case was structured was that the law and the legal implications were separated from the quantum. And what that means is that first we've had legal argument that the judge has made a ruling on, and now our next stage is to prove the quantum, the amount that our clients are entitled to. And the assistance of 100% liability means that that when we prove the amounts, and if we do prove the amounts, that in this next phase, it means that the minister would be liable to pay that 100% of the amounts. So if I can give you an example, for example, some of our clients have suffered significant PTSD, which have manifested in certain mental health constraints on their part, which requires them to have long-term, if not lifelong, access to mental health care. And so the minister, and so that would go into us having to prove the amount that they would need in order to sustain that. That the minister would have to then pay, or at least the Department of Justice and Correctional Services.
Now your claims, finally, Nabeelah, are obviously for an amount that you expect to be paid to your clients. Amongst your application, has there been a lodge to rescind some of the charges, or the term, or reduce the term of these prisoners or inmates?
No, there hasn't. So just to be clear, some of our clients have been fortunate to be released on parole, but that is not related to the judgment itself.
Nabeelah Mia, appreciate your time as you talk to us about the 5 minutes to win the torture case against the government.